turn there now. I'll just read from there for a moment. The purpose is to prevent third-party tax preparers from making false statements within the self-reporting tax system, where they could consequently cause a large population of self-reporting taxpayers to make false statements in their tax returns. And that is why we conclude that the sanction has a regulatory purpose.
And you just simply state that, though there's not some House of Commons debate transcript or some academic paper on this issue relating to the purpose?
Not to my knowledge.
Okay.
Thank you. I'll continue now and move to the second part of the criminal in nature branch. I just want to mention that our friends have argued that the amount of the penalty is disproportionate to the loss incurred by the Crown. And I'll address that again in the penal consequence branch of the test, but I will speak to it here also. And as I mentioned, the purpose of the sanction itself is preventative. And that preventative purpose is to prevent the false statements from being made at the outset, not to prevent or to pay back the loss that has occurred after the false statements are made. And so now I'll discuss the administrative procedures that attach to this penalty. It is our view that the procedures that attach to the penalty, which are described in detail at paragraph 38 of our factum, are clearly regulatory. There's no charge laid, there's no imprisonment that is threatened, there's no arrest of the individual. These are clearly regulatory procedures and administrative in nature. Okay? I'll now move to the penal consequence branch, which is the second branch.
In a way, I mean,
Yes.
I appreciate, there's no arrest, but there's also no opportunity for a trial. There's no burden of proof placed on the government.
Yes.
Isn't that kind of a circular argument that because the government hasn't created procedural safeguards, then we should assume that procedural safeguards aren't required by the Charter?
That's an interesting point. And I think I'll respond to it by saying that the administrative procedures are just one subset of the elements under the criminal in nature branch. And it's true that the absence of the criminal procedures alone does not automatically make the provision criminal in nature, or administrative in nature, rather. So in sum, the fact that the objective of the act is regulatory, the objective of the section in particular is regulatory, and the administrative procedures that attach to this section are regulatory, in sum, lead to the conclusion that it is not criminal in nature.
There is that interesting aspect, though, of penalties generally, even in the civil context in tax, that the Crown does bear the burden of establishing, it's only on a balance of probabilities, but the burden of proof, which is normally in the Crown's favor in the self-assessing system in relation to the assessment itself, does reverse.
Mm-hmm.
What do you say about that?
What do
Is that
say?
a signal that there is some aspect of the nature of this penalty, just like a Section 163 sub 2 penalty, that has a criminal element to it? It's got a criminal sort of a nature, because the burden is already flipped, even in the civil context in the tax court.
Respectfully, I would disagree with that. The burden of proof, I've described why the Wigglesworth test is the correct test to apply here, and the burden of proof it could only be discussed under the administrative procedures section of the criminal in nature branch, and it's our view that the procedures here in this case simply don't rise to a criminal procedure.
But they're closer than the ordinary civil standard for any other type of assessment under the Act.
And that is correct. And I'll just repeat the answer that I gave to Justice Kindertruck, and just say that the objective of the Act as a whole is regulatory, the sanction itself is regulatory, and the administrative procedures, while they may be more criminal than the typical civil case, do not rise to the level of a criminal proceeding. Okay?
Is there a cutoff point? Is there a level to which, if it had not been 135 unsuspecting taxpayers, it had been 400, she had somehow managed to convince, a few other friends and family to buy into to
Sure.
the scheme and they had based their tax return on some false statements, then obviously the penalty then could be in the millions.
Certainly.
So is it then
Certainly. And I'll answer your
penal in
question
nature?
just by reminding the court that here, when we're talking about the criminal in nature branch, we're concerned with the nature of the proceedings themselves, not the act committed by the individual. So we discuss the act more when we discuss the penal consequence and the impact of the provision. But here, whether she advised 400 people or 500 people is not relevant to whether the proceedings and the provision itself is criminal in nature. Okay? And I'll move to the penal consequence branch right now and discuss the magnitude first to answer your question more fully. So the penal consequence branch, I have two submissions. Number one, that the provision here does not redress a wrong done to society. And again, I'll just quickly state that the purpose is to prevent non-compliance and to uphold the regulatory scheme of the Income Tax Act as a whole. Okay? And second, I'll actually argue that the provision and the penalty assessed is actually proportionate to what is required to achieve that goal of securing compliance with the Regulatory Act. So my friends have argued that the penalty is disproportionate to what is required. And I'll just remind the court here that the appellant made 135 false statements in this case that resulted in almost $4 million of fictitious tax receipts to be submitted. It is our submission that a $500,000 penalty is actually not disproportionate to that number. It's not far in excess and does not rise to the level of punishment. That being said, we don't pretend that a $500,000 penalty is not a lot for an individual to pay. But I'll point you
Is there
now.
evidence in this case of any gain by the appellant derived from the misconduct?
Yes, well, she did pay $1,000 for her original opinion letter, but that is not an issue in this case.
Sorry, she received $1,000.
Yes,
Okay.
she did. She charged $1,000 for the original opinion letter relating to the overall scheme, but that is not what she's penalized for. And I'll just mention that the penalty here is calculated via a formula based on the potential tax loss incurred by the Crown. Not
But
the
is there any consideration of the ability of the appellant to pay the penalty?
There is not, and it is our submission that there should not be, because Ms. Gandon could just as easily have been working for a large accounting firm, a large law firm, and basing the penalty on ability to pay leads to the conclusion that the smaller the practitioner or the more affordable the false statement, the less the penalty that would occur.
It's just, it strikes me there's some potential for inequity. I mean, just in a common sense way, when you're dealing with an ordinary taxpayer making a misstatement, you have some refuge in the thought that, well, they kept the money, they didn't pay tax on this money. If they dissipated it or spent it, well, that's their problem, but they gained money, which they ought to be required to pay back.
Mm-hmm.
That's absent in this case. There's no link between the misconduct and any gain derived by this particular individual.
That is true.
And there's also the aspect, so I'd appreciate your comment on that, but also the aspect that there doesn't appear to be a whole lot of leakage to the fisc. There are only a very small number of charitable purported charitable donors whose claims were allowed in error by the minister. Most of them were captured, so there wasn't a huge amount of damage.
That is true, and I'll answer your question. My answer is twofold. First, I'll just mention again at paragraph 37 of our factum that the sanction aims to prevent the false statements from being made at all, and not to prevent or pay back the loss that occurs as a result of the false statements. Therefore, penalizing only third parties whose statements are missed and actually result in loss negates the regulatory purpose of the sanction. And I'll just speak briefly about the formula that is used to calculate the penalty. And that is paragraph 55 of our factum. And as I stated earlier, the monetary value of the penalty is significant in this case because it's directly attached to the scope of the scheme that the appellant participated in and endorsed. It's not a discretionary formula. It's not like criminal sentencing principles. It's standardized.
Is there any relief against such a harsh penalty, such as if someone were unable to pay $500,000, I was fined $500,000, I wouldn't be able to pay it. Is there any relief for that, for a harsh penalty?
That goes beyond my knowledge. But what I will say is that the relief available, again, relates to ability to pay. And that is not a part of the formula used to calculate the penalty.
Well, I am looking at paragraph 56 of
Yes.
Justice Stratus's decision in the Federal Court
Yes.
of Appeal. And he says that relief against harsh penalties can potentially be had under subsection 220, sub 3.1 of the Act. So I suppose I was testing you there a little bit.
Okay.
And yeah, and the ability to pay is a criteria.
And the ability to pay is a criteria, so.
Okay. I suppose I'll just reiterate that in our view, the ability to pay shouldn't inform our decision of whether it is a true penal consequence. And I'll conclude by just mentioning that, again, that the Income Tax Act is a regulatory act and it relies on honesty and integrity for its success. And it cannot be accepted that the regulation of third-party professionals whose conduct can threaten the system is outside the scope of this act. Third, the appellant was required to provide notice, as my co-counsel stated, in the lower courts, and failed to do so. The Supreme Court of Canada erred in exercising its narrow discretion to hear her constitutional argument at all. And in the alternative, because the provision is not criminal in nature and no penal consequence occurred, the appellant was not a person charged with an offense and should not be afforded Section 11 protections. And so we would request an order varying the Supreme Court judgment with respect to the exercise of discretion, notwithstanding the failure to provide notice, or the dismissal of this appeal with costs to the respondent. And if there are no other questions, I'll conclude there.
Thank you. We have an additional participant who has the pinch hit if one of the four are unable, or why, right? Okay. Oh, sorry, rebuttal.
Yeah.
So he's doing monthly work events each week,
Okay.
and so he'll do Zena's tonight
Again.
after we're
All right.
finished with the rebuttal. So,
Okay,
so rebuttal?
apply.
Yes. We'd just like to reiterate that discretion of the Supreme Court was indeed used appropriately. In this case, no Attorney General nor counsel for the defendant has suggested that any additional evidence was required or is required, let alone ask for any permission to supplement the record.
What do you make of the point, though, that the onus should be not on attorneys general to demonstrate prejudice, but on parties who seek to avoid the application of the notice provision to show that it's appropriate to proceed?
Yeah, at that stage, the onus is upon the party to show there is no prejudice, but that is a factor in showing that, I believe, that there is no more evidence needed, that the evidentiary record is complete. At this point, I mean, we're trying to overturn the Supreme Court's decision. The onus is now switched, but as the Supreme Court has pointed out in Rainick and Molden, undue process with unnecessary expense and delay can prevent the fair and just resolution of disputes. And I just point that out to emphasize the importance that discretion can play in providing access to justice in the modern day. Secondly, our learned friend suggests that the purpose of the act and the sanction is regulatory. It's our submission that they don't provide enough justification for that. In our factum, at paragraph 24, you can see that who was then the senior chief of the tax policy branch of the Department of Finance is quoted at paragraph 24, from there. He says it's not likely that Revenue Canada is going to be able to prosecute on a criminal basis all of these people. And we take that as some evidence of the purpose of that sanction, and among other things within that factum. So,
Is that speaking to deterrence? I mean, I take that to be, you could interpret that as saying, well, we need this as a measure of deterrence because everybody knows we can't prosecute everyone.
well, to find deterrence in our opinion isn't determinative that it's not criminal, because criminal sanctions also have a deterrence aspect. But what I would interpret this to say is that they aren't able the burden's too high, and so they tried to lower the burden in an effort to prosecute the same type of thing that was previously being prosecuted on a criminal basis. And we'll leave our submission to that.
Thank you. Mr. Hutchison?
Thank you. As Justice Silva perhaps is anticipating, I'm going to defer making my argument till I've had an opportunity to fill my cup with water and cold, and otherwise might erupt in hacking cough. I appreciate your patience. The substantive issue before the court tonight is whether Section 163.2 of the Income Tax Act engages Section 11 of the Charter. Section 11 is triggered if the appellant is a person charged with an offense. Tonight I'm going to be arguing that she isn't a person charged with an offense because the proceeding in question, created by Section 163.2, isn't criminal in nature, and because the provision doesn't impose a true penal consequence on Ms. Gandon. It's our view that the test in Wigglesworth, which I've just gestured towards, which has two parts, which asks the court to inquire whether a proceeding is criminal in nature and whether it imposes a true penal consequence, is the correct test for determining whether Section 11 should apply. It permits balancing between consistent and strong protections for those who need them because they're faced by the prosecutorial power of the state, and effective regulatory action. And it's our submission that the court ought to strike a balance tonight so that it preserves the efficacy of an important regulatory measure. To begin my argument by addressing the proceeding, I'll argue that it isn't criminal in nature. In Martineau, the court directed that three issues ought to be considered under this branch of the Wigglesworth test: the purpose of the statute and the provision, the purpose of the sanction imposed by the provision, and the process leading to the sanction. I'm going to discuss each of those in turn. I'll emphasize at the outset that this branch of the test focuses on the nature of the proceedings, not the nature of the act. The question isn't whether or not the appellant's conduct in this case could be grounds for criminal prosecution, but whether the provision in question, Section 163.2, is criminal in nature, or gives rise to a process that's criminal in nature.
I recognize that you've cited Martineau in your factum relating to the purpose of the sanction in 163.2 being regulatory because it does not punish but aims to deter. But in what authority do you have for that general proposition, that the provision doesn't punish but aims to deter? What is it about the provision or perhaps surrounding legislation or the act generally? How do we get there from Martineau to this exact provision?
Well, it's our contention that the deterrent purpose of the provision itself emerges from the language of the statute. And I have in particular in mind subsection 4, where the provision makes a preparer liable for a penalty in the event they make a statement that could be used for the purpose of the act. To my mind, to our mind, that suggests that this is intended to be an early intervention an intervention upstream from the filing of a return. It's designed to stem these kinds of misrepresentations before they're relied on by taxpayers in order to avoid tax.
I wonder about that. How would anybody ever detect whether a preparer made a statement that could be used in a misleading way unless the statement was actually used somewhere? How would we ever know what happened?
The point's well taken. I think in practice, it's unlikely that any person making a false statement would be subject to a penalty unless that false statement were used by a taxpayer. That being said, it is the case in our view that the penalty applies to conduct that logically must occur before a return is filed. And it's in that sense that, in our view, it's preemptive.
Thank you, counsel.
Thank you. I'll proceed now, having discussed the purpose of the sanction itself, to discuss the purpose of the act. I think nobody disputes that the principal purpose of the Income Tax Act is regulatory or administrative. It's mainly designed to raise revenue, to promote honesty and integrity and self-reporting with a view to that goal. And it's our submission that Section 163(2) serves those regulatory objectives. I've discussed the purpose of the sanction in some detail already. I'll confine myself now to emphasizing that in our view, its aim is to promote honesty and integrity on the part of tax preparers, and that their conduct is closely connected with the conduct of tax filers. Now I'll discuss the administrative procedure that's an issue with respect to Section 163.2. My co-counsel has addressed the appellant's argument with respect to Section 34, sub 2 of the Interpretation Act at some length. I'll confine myself to emphasizing that it's, in our view, clear that Section 152 applies to this provision. It follows from that the minister has authority to make an assessment of a penalty under Section 163.2, and along with that assessment comes all of the procedures characteristic of the assessment process. A penalty emerges from an audit, it's referred to the third party penalty review committee, proceeds to an assessment, and that assessment is followed by an optional objection, which is overseen by the minister, and an optional appeal to tax court. And that procedure bears virtually no resemblance in our submission to the procedure for trying a criminal offense. There's no charge, no information is laid, no summons is issued. There's no trial before the penalty is imposed. No criminal record emerges from the proceeding. So it's our submission that Section 163.2 does not have a criminal nature. It's not criminal in nature.
Is there some marking of criminal in nature, of criminal nature to this idea of the reversal of onus, where in the assessment of taxes, generally speaking, the minister bears the benefit of the onus of proof in the sense that the assumptions made by the minister deemed to be true unless they're established otherwise on a balance of probabilities, whereas in the situation of penalties, and penalties are even distinct from 152 sub 4 statute barred assessments where the burden is reversed, is that the minister does have to prove the penalty. Is that an indicia in your mind? And if it's not, why not?
I don't think so. But I think it is clear that there's an important distinction between penalties imposed under the Act and ordinary assessments. And there's a sense in which the imposition of a penalty is, I'm disinclined to use the word punitive for reasons you can guess, but it's more onerous, if you will, than an ordinary assessment. And we think that the reversal of onus is an appropriate response to that, but that's all the response that's necessary. It provides adequate protections in our view. I'll proceed now to consider whether Section 163.2 imposes a true penal consequence. The focus in this branch of the analysis is on the impact of the penalty, not on the procedure that leads to it. A penalty imposes a true penal consequence, when it redresses a wrong to society. On the other hand, when its purpose is to promote compliance with a limited regulatory regime, it's administrative. Now, it's our submission that for two main reasons, this penalty ought to be viewed as principally regulatory. First, we submit that it's proportionate to its regulatory purpose, and second, that it doesn't stigmatize those who are subject to it in any important way. And I'll consider the magnitude of the penalty of proportionality first. By way of point of departure, we'll observe that magnitude alone isn't dispositive whether a penalty is a true penal consequence. In other cases, penalties of up to $1 million or $10,000 a day have been found to be administrative. What that suggests, I think, is that the determination is contextual. And I'll take this opportunity to remind the court of the context here. The appellant made 135 false statements, made or acquiesced to 135 false statements. She issued receipts totaling approximately $3.9 million. Given that the penalty is approximately half of the tax that could have been avoided, those statements created the risk that about $1 million might, pardon me, it was about $1 million might be at risk for the FISC, though the loss in the event was not that large.
So that sounds to me like a wrong to society. It's not what the appellant gained from her misconduct, it's what the public lost or potentially lost. Isn't that redressing a wrong to society?
I don't think so. I think that what we see here is proportionality between the scale of the appellant's misconduct, or in other words, the scale of the regulatory problem that Parliament was trying to address, and the penalty. I don't think that suggests that a wrong is being redressed.
But isn't deterrence achieved adequately by depriving the party of her wrongful gain and imposing a penalty that's proportionate to that, rather than to this damage that's done systemically?
Well, I think that the penalty here has to take account of the possibility that some false statements are going to escape detection. It can't just be, or it can't be strictly proportionate to the appellant's gain, because if it were, then it'd be possible to make a going concern of issuing false statements like this on the premise that you'll only get caught some of the time.
So it would just be a cost of doing business.
Precisely.
On the magnitude, what do you say about the situation in Wigglesworth? Because the fine in Wigglesworth was very small, wasn't it? Like only a few $100s?
Yes.
Okay, whereas here we're talking about $500,000. What do you say about the appellant's argument that the fine here is excessively large by comparison to some fines or penalties that have been found to attract charter protection that are substantially smaller, and some of them in the hundreds of dollars?
Well, in Wigglesworth, as I understand the case, and perhaps the court understands it differently, what attracted charter protections wasn't the $300 fine, it was the risk of imprisonment. And there's no such risk here. Now I'll proceed to consider stigma. The appellants have argued that Ms. Gannon is stigmatized by this penalty. With respect, it's our view that that simply isn't true. The penalty in question is calculated by the application of a formula. It doesn't take into account the appellant's moral blameworthiness. It's not designed to elicit social condemnation. Moreover, unless there's an appeal, it's entirely private. Nobody learns of it, and indeed, it's an offense to disclose information about it.
But as a lawyer, she's already facing social condemnation. So, she's got this $500,000 fine now. There's a public statement related to and finding that she's engaged in some conduct that was
Yes.
false. She's made 135 false statements. Her professional integrity, her profession is on the line. And there's no stigma there.
I think when we talk about stigma, the stigma to which the appellant might be subject, we have to be careful to distinguish the sources of that stigma. It's our submission that any stigma to which Ms. Gandon is subject by virtue of these events is attracted first by her conduct. It's our submission that she's stigmatized in part simply because she engaged in dishonest or incompetent or at least careless behavior.
But that's precisely why criminals are stigmatized and why criminal
I don't
activity
think
is
so.
stigmatizing.
I think what's at issue here is whether the proceeding and the penalty cause stigma. I don't think it's the case that Ms. Gandon is being stigmatized because she's been subject to the penalty. I think she's being stigmatized because she engaged in conduct that led to the penalty. The stigma,
But
in my view,
your friends
is...
say, well, it's a really big penalty, and people
Newsworthy.
rightly assume somebody who's been given a really big penalty has done something really bad. Doesn't that argument have some attraction?
Yes, I think it is an attractive argument. As it happens, I can't subscribe to its conclusions. I think the other reason that Ms. Gandon has, if she has been stigmatized, is by virtue of the publicity that her case attracted. But that's essentially the consequence of a unique set of circumstances. She's among the first tax preparers to appeal a penalty to the tax court. She advanced a novel constitutional argument which was successful in the tax court. The litigation eventually proceeded to the Supreme Court. I don't think that, as a rule, other taxpayers contesting a penalty like this are going to attract the same kind of attention. And again, I'd suggest that that means that the penalty itself is not what's at issue here. That's not what gives rise to the stigma.
Do you want to just make some concluding remarks, Mr. Hodgson?
I will, thank you. By way of summary then, we submit that Ms. Gandon was not a person charged with offense because Section 163.2 doesn't impose a true penal consequence and because the proceedings are criminal in nature. Moreover, Ms. Gandon's failure to give notice should be fatal to her constitutional argument. Accordingly, we request that the court dismiss this appeal with cost to the respondent.
Thank you.